The Fourth Amendment, Search and Seizure in Schools, a critical analysis research project by Keisha Bowens for EDS 707, Law, Policy, and Governance. The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Constitution, through the Fourth Amendment, protects people from unreasonable searches and seizures by the government. This amendment does not safeguard citizens against all searches and seizures, but only those that are considered unreasonable under the law. Whether a particular type of search is considered reasonable in the eyes of the law is determined by balancing two important interests. On one side of the scale is the intrusion on an individual's Fourth Amendment rights. On the other side of the scale are legitimate government interests like public safety. When the lens has focused specifically on schools, the courts have balanced the school's legitimate need to maintain a safe and secure environment where learning can take place against students' reasonable expectation of privacy for themselves and their belongings. These expectations are less than those of adults and minors outside the school setting because supervision and control must be maintained on K-12 campuses. There has been an increase in the presence of surveillance and law enforcement in public schools in recent years. This upsurge has changed the role of teachers and administrators to rule enforcers. The surge in school shootings has resulted in more police officers being placed in school buildings. These changes have raised valid questions. Are students still guaranteed Fourth Amendment protections? How are public safety concerns balanced with individual liberties? Educators must be able to protect the original objectives of keeping students safe in an acceptable educational setting without sacrificing Fourth Amendment rights. The true test for educators is where to draw the line. Prior to 1985, it was unclear whether and how the Fourth Amendment applied to students at school. The Supreme Court used 4 landmark cases to set the standard for school searches and seizures. New Jersey versus TLO in 1985, Vernonia School District versus Action in 1995, Board of Education versus Earls in 2002, and Safford Unified School District Number 1 versus Reading in 2009. New Jersey versus TLO was decided in 1985, and U.S. courts have debated where to draw the line when considering student rights ever since. In deciding TLO, the court held that neither a warrant nor probable cause was required for on-campus searches of public school students and their personal belongings by school officials. Because order has to be preserved in educational institutions, schools were given leniency while supervising students under their care. A 2-pronged test was developed by the court to establish reasonableness when conducting individualized school-based searches. Number one, whether the action was justified at its inception, and number two, whether the search as actually conducted was reasonably related in scope to the circumstances that justified interference in the first place. After this critical case, the court further diminished students' privacy rights in Vernonia School District versus Action and Board of Education versus Earls. In 1995, Vernonia rejected a Fourth Amendment challenge and held that a school district's policy authorizing random urinalysis drug testing of student athletes was reasonable and constitutional. The school's interest in preventing drug use outranked student privacy interest, and the ruling allowed the drug testing to continue. This low standard was reiterated in the Earls case in 2002. The court decided that middle and high school students participating in any competitive extracurricular activities had to consent to urinalysis drug testing. The requirement prevented and deterred drug use among students and did not violate the Fourth Amendment. It wasn't until 2009 that the Supreme Court finally found a school search unreasonable and unconstitutional. In Safford Unified School District Number 1 versus Reading, the strip search of a 13-year-old female student suspected of hiding and distributing prescription drugs was deemed unreasonable. Since the rulings were handed down, these 4 Supreme Court cases have been used as the standards when it comes to searches and seizures in the school setting. However, as schools, students, technology, and our world continue to evolve, these cases have become somewhat outdated and may not fully address current school issues that now arise. Educators grapple with concerns like technology devices, surveillance, police presence, and just how far to go while protecting the learning environment. Researchers point to the historical justification courts cite to compress students' rights, specifically their Fourth Amendment rights, in order to advance their educational interest. The question to consider is if that justification holds true when the learning environment deteriorates and actually harms students' interest. The implementation of strict measures in schools serving primarily minority and low-income students has been noted. Metal detectors, random sweeps for prohibited items, controlled access to school grounds, locked or monitored gates, and security cameras are more likely to be used at schools with these diverse populations. These measures have received far less attention in the legal circles, but must be addressed. Intense security operations in low-income area schools, much like unreasonable violations of student privacy anywhere in America, are problems that must be held in check. The detrimental effect to student learning and positive growth can be profound. Whether conducting suspicionless searches or creating harsh, prison-like school environments, educators who participate in these practices are contributing to a degraded learning environment and harming students in the process. The precedent set by the Supreme Court should not be set aside as schools seek to create a balance between keeping students secure and protecting their Fourth Amendment rights. As educators strive to keep schools safe, they must also endeavor to protect their constitutional rights. An understanding of the Fourth Amendment provides direction for conducting searches in the school environment and helps school leaders maintain the balance between safety, rights,